Amendment proposed after clause 166, insert the new clause as printed on the marshalled list.
I have enthusiastically added my name to this amendment 438B or 438EF on recording of biological sex in police data to prevent reliance in terms of administrative records on self-identification and so on. I think the noble lady Baroness Cash has laid out the arguments with great clarity and precision, and I appreciate that. In the past, I've tabled similar amendments to previous bills. Unfortunately, my attempts were far less elegantly argued than the noble lady Baroness Cash, but they were also rebuffed as though I was motivated by some ideological attempt at undermining inclusion policies. But actually, nothing could be further from the truth. The truth is that I want ideology out of data and data collection. And I think that there is a slightly different atmosphere now, I hope, that we can have this discussion, because since then the Supreme Court's clarity in relation to the equality law in the distinct category of biological sex in relation to single-sex provision gives us an important marker. But we've also had the Sullivan Review commissioned in 2024 by the Secretary of State for Science, Innovation and Technology under Rishi Sunak's government, but also, I think, broadly welcomed by the present government in terms of its themes, which is to identify obstacles to accurate data collection and research on sex and gender in public bodies and in the research system, and to set out good practice. I'd like to just state at this point that I think we owe a huge thanks to Professor Alice Sullivan for her 226-page review. I think it was a real work of public service. And it found that the recording of sex and gender across the justice system and police forces is highly inconsistent and in a muddle, and therefore is not reliable. And I think that this really matters, because anything that erases biological sex or confuses biological sex from official data in relation to crime is really problematic. Many of the policies in this bill, if they are to be effective, rely on evidence, and that evidence must be based on, therefore, reliable data. I got interested in this issue some time ago talking to academics in criminology and in research, because it's important for their research that official crime data, such as recorded crime, is accurate. Accurate data is what policymakers also need, as well as researchers, to analyse patterns of offending, to allow interventions to be developed and resources to be targeted effectively. Importantly, criminal justice data needs to be credible and consistent. However, the conflation of sex and gender compromise official trustworthiness, quality and the value of data for policy and for researchers in academia, but also for a public understanding of the facts in relation to crime. And this point is increasingly key, as trust in criminal justice is no longer to be taken for granted. But the data is anything but consistent, as we know, because police forces differ from area to area, recording crime statistics variously, some by biological sex, others by concept based on the ever-fluid and subjective ideas around gender identity. And that has led to confusion and a conflation of sex and gender. The details of how police forces in England and Wales have recorded suspects' sex in crime and reporting was revealed a few years ago by Freedom of Information Access requests put forward by women's rights campaigning organisations at the time, and they showed that many police forces record suspects' gender identity rather than sex registered at birth, frequently on the basis of self-identification, and that has led to the muddle. Some forces even stated that they record the sex of a suspect who identifies as non-binary with the term indeterminate or unspecified. So this is not accurate data collection. Of the 26 forces that answered freedom of information questions, only one police force stated that they recorded biological sex clearly. 22 forces recorded gender identity, 20 on the basis of self-ID, and 17 forces answered the specific question on how rape suspects' sex was recorded. 14 recorded via gender identity, with over 50% doing so on the basis of self-identification. So these data recording decisions made by individual police forces affect the criminal justice system in a wide range of ways, not just in terms of data, but that is because data collected by police forces are transferred over onto other data management systems, including the Police National Computer, one of the main sources of information of disclosure and barring DBS checks, and also the annual data requirement provided to the Home Office for research and statistical purposes, and magistrates and Crown Courts case management systems all use this data, but it's unreliable. So I do think that accurate statistics are vital for evidence-based criminal justice policy, or there can be serious consequences in terms of unintended outcomes. Professor Sullivan, in fact, found that it is quite possible that if somebody who has been arrested and has legally changed their gender and not informed the police, they could be released or otherwise dealt with before any link to their previous offending history is unknown. That is a confusion, an outcome that nobody wants, but is because we are not collecting data accurately. As we've heard, but let me stress, there are different offending patterns between males and females. And I think the noble lady Baroness Cashel has explained that really usefully for us. Males commit the large majority of offences per se, and some offence categories are only very rarely committed by females, such as sexual offences or violent crime in particular. That means that even if only a small number of natal males who identify as female are recorded as women, this skews the female sex offending statistics in a misleading way. I don't know if my noble lords will remember in 2021, when there was a File on 4 on BBC Radio 4 investigation. They had used freedom of information requests to police forces, and they had declared, as a consequence of the information they received back, that there had been a huge spike in female-perpetrated child sexual abuse. There was hysterical headlines, women who abuse, there was all sorts of academic discussions on female paedophilia and the rise of it. But actually it all went a bit quiet when everybody realised that this was based on statistics that actually conflated sex and gender. And suddenly everybody realised that maybe this new crime epidemic wasn't quite as it seemed. But the main thing is it could be, but we don't know, because the statistics are not reliable. And so I think that is a real problem. So I urge the Minister to accept this amendment. Professor Alice Sullivan really has done the hard work for government in her review, setting out good practice guidance, such as the default target of any sex question should be sex, i.e. biological sex, that sex and gender identity are distinct concepts, and questions which combine sex and gender in one question should not be asked, and that the word gender should be avoided in question wording, as it has multiple distinct meanings from the traditional but now corrupted synonym for sex because of gender identity as an ideology. I think that we all will agree that we need reliable data. And by the way, that should include and can include data on gender reassignment as a separate protected characteristic, even on self-ID in terms of keeping that information. But it should not be the basis on which we collect collect crime data in relation to sex-based, in relation to the different sexes. But it is important, of course, to acknowledge that it's possible that transgender people or people who identify as transgender might well be the victims of crime more regularly, or indeed they may be perpetrators of crime. And I'm happy to know that information as well, but not through the conflation of sex and gender in the bottom line collection of in the bottom line collecting of crime statistics.